To make the best use of the session, I suggest you do two things. Number one, go through my theory session on legal reasoning. The link to the session is given on the description below. Second, create a free sign-up account on our website and solve the exercise on your own before you go through the video. The process for the free sign-up is also given on the description below. Now that you would have done both the things, let's start with the class. Hello students, welcome to this class in which I'll practice old CLAT pattern questions. Now, why do I do that with my students? Because the pattern has changed. This pattern questions are not expected. But why do I do this? The reason is it's a good practice for the new pattern questions. In the old pattern, the principle was given to us, and we knew that we have to apply this principle on the given question. So it was very easy and straightforward. So if you're not able to apply a principle which was given to us in the old pattern, the new pattern, we will not be able to be good at it, because there we have to first identify the principle. So therefore, I make all my students practice old pattern questions where they have to apply principle to the facts. So let's start with the class. All right. So this is the first question. I suggest that those who are doing it for the first time, haven't gone to our portal, pause the video, attempt the question, and then come to my solution. Okay. So here, this is a decision that we have to make. Can A get his car back? The first decision is yes or no. That is what you have to decide. And you have to apply the principle to make that decision. Now, the principle said, if the consent of a contracting party, so consent is vitiated by fraud, as in you receive the consent because of some fraud, because you committed a fraud, this contract can be avoided. Okay. So all we have to figure out from the facts was whether the consent was achieved by committing a fraud or not. Look at facts. A had advertised the sale of his Maruti car. B approached him as a buyer, and both A and B settled for a price of rupees 1 lakh. So far, so good. Okay. Thereafter, B proposed to give a check for rupees 1 lakh, but A insisted on cash. A wanted cash. At that stage, B introduced himself as the son of a well-known film star, Shekhar Kapoor. And in fact, there was a great deal of resemblance between B and Shekhar Kapoor. On the strength of B's representation, because of this, A accepted the check. So his consent to accept check was achieved when he told him that he is actually son of Shekhar Kapoor. Okay. Subsequently, the check bounced, and it was found that B was an imposter, which means he was a fraud. He was no son of Shekhar Kapoor. At this stage, A wanted the car back. Can A get his car back? Was a fraud committed? Yes. So can the contract be avoided? Yes. So the answer is this, these three. Now, the explanation has to be one which applies the principle. Because B was an imposter, okay. Because the check subsequently bounced, this is not what the principle said. Because A's consent was taken fraudulently. This is where the principle is applied, right? You might say that B happened. Yes, because B was an imposter, therefore the principle will get applied that the consent was received by an imposter by committing a fraud. So C is the better answer than B, because in C the principle gets applied. The first answer is C. Let's move to question number 2. Okay. The consideration or object of an agreement is unlawful if it is forbidden by law. Every agreement of which the object or consideration is unlawful is void. So if you're entering into a contract or an agreement, the objective or consideration of which is unlawful, that is void. Okay, that we have to apply here. X promises to pay rupees 50,000. That's the consideration if Y commits a crime. So now object is unlawful. So this contract is void. X further promises to indemnify Y against any liability arising thereof. Y agrees to act as per X promise. So they can enter into an agreement with each other. But if one of the party were to default, can they get this enforced in a court of law? No, because this is not a contract. The object was unlawful. Which of the following derivations is correct? There is a contract between X and Y. No, there is an agreement between X and Y. There is an agreement between X and Y which can be enforced. No, the object is unlawful, cannot be enforced. Voidable contract, we know nothing about voidable from the principle. Look at C. There is an agreement between X and Y which cannot be enforced by the court of law. This is what the principle has said. So second also, the answer is C. Next question. Okay. Agreement may be oral or written. However, if a law specifically requires that an agreement must be in writing, then the agreement must be in writing. So if the law says, let's say the relationship between a teacher and a student has to be in writing, and if we get into a verbal agreement, that agreement would not be enforceable if the law specifies so. ठीक है? तो अगर law ने ऐसे कहा तो. Now, a law specifically requires that the agreement relating to the transfer of copyright in the case of a novel between an author of a novel and the producer of a motion picture, this agreement must be in writing. So law says that the agreement between the author and if someone is to make movie on that novel, that has to be in writing. So if it is not in writing, it won't be enforceable. This is what the principle says. Let's look at the facts. The author of a novel, Love at Lost Sight, had several rounds of discussion with the producer of a motion picture. We quickly read it. He received the payment also, who happily accepted the amount. Okay. So till now, there has been no written agreement. So will this agreement be enforceable? Will it be considered as a contract? No, because law specifically says that an arrangement or agreement between the author and the producer of the film has to be in writing. This was not in writing, so this won't be enforceable. So any party can, walk out of the contract. It's not just the author, even the movie producer could actually have walked out of this contract that, okay, I don't want to produce this film. Okay, let's see. What could happen? The author is likely to succeed in the case as the agreement is not in accordance with the law. The law said it had to be in writing. It was not. So I'll keep this for a while. Let me check B. The author cannot succeed. He has given his consent. No, he can succeed. It was oral, not in writing. This again, because it is oral, not applicable. The author can succeed in the case as the consideration is not adequate. No. Only A, the principle applies. See, the problem that many students face or encounter in such questions is especially if they know law, they start applying law. You're not supposed to apply law. You only are supposed to apply the principle which is given to us. The principle only talked about written and verbal agreement. In the case of between author and producer, it has to be in writing. Because it is not in writing, it is not in accordance with the law, and therefore option A is the correct answer. Number 4. When a criminal act is done by one person in furtherance of the common intention of himself and some other persons, each of such person is liable for the act in the same manner as if it were done by each one of them, right? So basically, what does this principle say? Let's say let's say Abhishek sir and one of my student X and Y, we have a common intention of robbing our student Z. So all three of us planned and we had a common intention of robbing our friend Z. Now I engage myself. I call Z to my place that, okay, I'll take your doubt session. Okay, come over. I'll take your doubt session. I'll teach you law. I'll teach you logic. And just to keep him occupied, I know that his parents are not here. X goes there. He guards the entrance gate so that he can inform Y if somebody is coming into the house or not. And Y actually gets into the house and robs the house. So in this case, all three of us would be guilty of theft. I was teaching, X was just guarding the house, Y was actually involved in theft, but all three of us would be guilty of theft because we had common intention. So the common point here was, the main point here is we should have common intention. Okay, now let's look at the facts. Burglary. So the common intent is to commit a theft. ABC have a common intent of committing a theft. They broke into a locked house. However, before they had finished the work, a domestic servant appeared from the outhouse and started shouting. A, B, and C left the house and started running away. They were pursued by a small crowd. A, on being caught by X, some person, one of the persons pursuing them, stabbed him and ran away. By the time B and C had disappeared, X died on account of the stab wounds. Later, the police arrested all three. they were charged for attempting burglary and murder of X. So obviously the question would be, can all three of them be charged for both the offenses? So let's see. So they had, see, you only apply the principle given to us, which is common intent. Do not apply the principle of, let's say, mens rea or murder or homicide. No, the only principle given to us here is of common intention. They had common intention of burglary. Did they had common intention of murder of X? No. A committed out of his own volition, out of his own will. So A is liable for murder of X, B and C are not, but all three of them are guilty of attempted burglary because इसके लिए उनका common intention था. So right, so fourth, the answer would be C. A alone is guilty of murder because there was no common intention. Right? Please restrict yourself to the principle given. उसके बाहर नहीं जाना है. ठीक है? Principle तक ही रखना है खुद को. All right. Let's come to number 5. Let's go through it quickly. Yeah. Whoever intentionally puts any person in fear of an injury to that person or to any other. It could be direct, it could be indirect, and thereby dishonestly induces. So intention is there to put any person in fear of any injury to that person or to any other, and thereby dishonestly induces that person so put in fear to deliver to any person any property commits extortion. ठीक है? ये करा intentionally, dishonestly induce kara to give you something, some property, then you would have committed extortion. Okay, now let's look at the facts. A entered B's house, caught hold of B's daughter C and threatened to stab her S daughter. Okay, B's daughter. Okay, so this would be B's daughter C and threatened to stab her if A did not give him 10,000 immediately. B did so. A is prosecuted for extortion. Yes, so there is he threatened and he also asked him to give him 10,000 bucks. So yes, he's committed of extortion. Simple question. This came in NLE 2010. So yes, you used to get such easier questions then. Okay, next question. Look at this question. Okay. What is the principle about conspiracy? Conspiracy is a combination between two or more persons. You have to have two or more persons formed for the purpose of doing either an unlawful act or a lawful act by unlawful means. So basically, it has to be a combination of two or more persons. Okay. X and Y conspire to poison Z. So poisoning someone is an unlawful act, and two people have combined. So conspiracy to lag raha hai. X, in pursuance of the conspiracy, procures the poison and delivers it to Y in order that he may administer it to Z. Y, in pursuance of the conspiracy, administers the poison in the presence of X and thereby causes Z's death. What offense, if any, has been committed by X and Y respectively? Now, here is the trap, right? The principle had only told us about conspiracy, but murder has happened. So people have a tendency to mark this one or this between C or D. But the principal said nothing about the murder, guys. So principal said, has given me criteria for conspiracy. So is there a conspiracy? Yes, there's a conspiracy. So we'll mark B. Do not fall in the trap. Do not mark something which is not given. Okay. Number 7. Go through question number 7. False imprisonment. Now the key word here is total restraint of the liberty of a person. It has to be complete, total, for however short a time without lawful excuse. Okay. Now A was driving down a road heading to her house. As she reached close to her house, she found that a few people led by B protesting against an unfair law had blocked the road. Okay. There was no alternate road to her house, and hence she was stuck there for around 5 minutes. So let's say if let's say A was driving this way and this was block and she had to go this direction, right? For 5 minutes she has to stay because there is no other way in which she could have gone to this route. all we had to decide is this a total restraint? This is not total. See, only one way restraint is there. She could have always gone back, right? You might say कि sir वापस जाएगी, time waste होगा, जो भी होगा, but total restraint तो नहीं है ना? She can always go back. So they have not, let's say, पूरी तरीके से उसका वहां पे रास्ता नहीं रोक दिया. It's not 100% restraint. You can always have gone back. So that is not total restraint, and therefore the answer would be C. Always focus on the key words, guys. Total restraint. ठीक है? All right. Number 8. Let's do number 8. Okay. Whoever enters into or upon property in the possession of another with the intent to commit an offense or to intimidate, insult or annoy any person, or having lawfully entered. So it's not necessary that without permission you get into the property. You might have entered lawfully upon such property, unlawfully remains there with an intent to intimidate, insult, annoy any such person, or with the intent to commit an offense, commits criminal trespass. So basically, whether you enter lawfully or unlawfully, that is not important. Your intent of committing 1 or 3 or 4 or 5 things, if you do that, that is criminal trespass. So if you enter lawfully but you remain unlawfully, so what is given here? Unlawfully remains there. Okay, so let's look at the facts. A went to Delhi Law College to participate in a competition. Okay, fair enough. After participating in the competition, A hid inside the campus. A hid inside the campus so that he could steal. This is his intent. So enter lawfully, unlawfully remain there with this intent. So yes, criminal trespass hai. So 8th, the answer is B. 8th, the answer is B. Let's do question number 9th. Nothing is an offense if committed by a child below 7 years of age. So the fact would be simple, guys. We just have to figure out कि age given है इस facts में जो किसी ने गलती करी होगी कि नहीं. So look at this. Fact situation. Adil, age 6 years. That's it. Khatam. He cannot be held liable for any offense now, as per the principle. Is a student of class 1. He placed his sharpened pencil on the bench with his pointed end up when his classmate Ajay stood up to an answer. काफी लोगों ने ये काम करे अपनी लाइफ में. ठीक है. Ajay gets hurt when he sits on the pencil and Adil and his friends have a good laugh. Ajay's father, on seeing this, action against Adil. Can he take any action against Adil? No, he hasn't committed any offense. Why? Because he is less than 7 years of age. So answer would be B. 10th. This is CLAT 2018 question. Quickly go through it. The doctrine of basic structure in constitutional jurisprudence means that the Constitution of India has certain basic features that cannot be taken away through amendments by the Parliament. The power of judicial review is a part of the basic structure, and it helps the constitutional courts to determine whether an amendment is against the basic structure or not. So basically, you must be aware of the Constitution, right? So Constitution में काफी rights हैं, काफी provisions हैं. So let's say, and in provisions code, the Parliament can amend, right? So they can amend certain provisions of, let's say, Constitution, right? So they can do that. But constitutional courts, they have the power to decide whether that amendment is valid or not, right? If they feel, as per the principle, I'm not sharing legal knowledge with you right now, as per the principle, if they feel that the amendment is impacting the basic structure of the Constitution, they can knock off the amendment. They can say that this amendment is not valid. So let's say Article 14 जो हमारा है, ठीक है? अगर मेरा उसमें वो right को, let's say Parliament says कि we are amending Article 14, and they can amend it. But later on, the constitutional courts, if they think that that amendment has destroyed or has affected adversely the basic structure of the Constitution, बस उन्हें ये prove करना है कि basic structure को impact करा है, they can call that amendment as invalid or unconstitutional. So let's look at this fact situation. Parliament proposed an amendment to limit the power of appeal against conviction for the offense of sedition. So some would be there, some processes there. They are, Parliament has proposed an amendment to this, and this has to be exercised only by Supreme Court of India. Which of the following statement is the most appropriate in relation to the legal principle stated above? ठीक है, इस principle के चलते क्या आप इसमें you can infer, right? The proposed amendment is against the doctrine of basic structure. We don't know that. The proposed amendment is unconnected to the doctrine of basic structure. Again, both the things we can't conclude. Whether this amendment is against the basic structure, we as a reader from this can't conclude that. The proposed amendment can be reviewed and struck down by the constitutional courts. Yes. If they find that this amendment is against the basic structure, they can do that. The proposed amendment is beyond the power of the Parliament. The proposed amendment is beyond the power of the Parliament. No, they can do that. They can always amend. Whether that amendment will hold ground or not, that is a question which is debatable. Not even debatable. The constitutional courts, if they can prove or if they feel that it adversely affects the basic structure, they say that the amendment is invalid. Okay, so today we practiced 10 questions. I hope you appreciate the point that we have to restrict ourselves to the principle to answer the questions. You have to make decisions. In both old pattern as well as new pattern, you have to make decisions. In the old pattern, the criteria or the principle was directly given to us. ये रहा, ये fact है, इस principle को apply करो और answer करो. The new pattern is, we are not given the principle directly. In the passage, which is around 450-500 words, there might be 2 or 3 principles. So you have to identify which principle will be applicable. So practice this. I'll do some 4 or 5 questions on old pattern questions. Then I'll start discussing new pattern questions with you. If you like the class, guys, please subscribe to our channel. And if you want me to come up with, or our team to come up with content on some other sections of, let's say, CLAT or specific topic, do write it in the description below. Thank you. We at Mentors Capital have curated the best test series for you. We can confidently claim that our test series is best in the market. So go and see it for yourself. Remember, coaching kahin se bhi. Test series from Mentors Capital.